Last Monday, Roe v. Wade was officially sent to the ash heap of history. And as I mentioned in my recent video about secret pro-life policies, the battle has just begun. Now we march forward. Now we go forth and get as many states as possible to pass pro-life legislation. We need to save as many children's lives as possible. We need heartbeat bills and total bans in as many states as possible. Congress and state legislatures can and should look at implementing some of the policies I mentioned for a post-Roe America in that video. But as mentioned by Justice Clarence Thomas, Roe v. Wade is not the only Supreme Court precedent that needs to be re-examined. Today we will be looking at Justice Clarence Thomas's concurring opinion from Dobbs v. Jackson to understand what comes next. Dobbs v. Jackson issued in a 6-3 ruling that the Constitution does not have a stance on the pro-life issue, and that states have a right to enact pro-life legislation as they wish. Justice Samuel Alito's opinion is the official majority opinion, but Justice John Roberts and Clarence Thomas both wrote their own separate concurring opinions, and Justice Thomas's opinion is very interesting. Thomas looks at 3 other Supreme Court precedents related to the Fourth Amendment's due process clause and implies that they may also be wrongly decided, calling for them to be re-examined. These cases are GRINSWOLD v. Connecticut, Lawrence v. Texas, and OBERGEFELL v. HODGES. Let's break down what that means. GRINSWOLD v. Connecticut is the 1965 Supreme Court case which created a right to contraceptive devices and medications nationwide. This came about as the state of Connecticut had banned birth control and convicted several doctors for explaining how to prevent conception and prescribing certain materials to do so. Similar to Roe v. Wade, the question must be asked, where does the Constitution prescribe such a right at the federal level? This case is built upon this fictitious right to privacy that simply does not exist in the Constitution. This is something they derive from the Fourth Amendment, which protects citizens from unreasonable search and seizure without a warrant and due process. How does that imply an absolute right to privacy? Why can warrants not be issued to conduct these searches if there is probable cause? This issue really should be left to the states under the 10th Amendment. To say contraceptives are a constitutional right is an opinion that stretches the Constitution far beyond its original intent. This right was fabricated by the far-left court of the 1960s. Now, this case was only mentioned in Clarence Thomas's concurring opinion. Sadly, the Alito trio don't want to touch these other Fourth Amendment precedents because they say a life is not at stake. But I say to them, is it your job to cower away from the truth? Are you a paid pro-life activist, or are you an adjudicator of the law as it is written? Clarence Thomas is right that the precedent of GRINSWOLD needs to be reviewed, even if he stands alone. Now, if this went back to the states, would it have much of an impact? Probably not. No currently elected Republican would touch the issue, but that mainly has to do with the Overturn window. See, now that the frame of discourse has shifted back towards the right, the main counter-argument to banning contraceptives has been weakened. That argument being that contraceptives prevent unwanted pregnancies that lead to infanticide. The fact that infanticide is being restricted and outright banned in so many states means that this could be the next step in combating hookup culture. Whether or not you agree with banning contraceptives, the truth is that this debate will slowly make its way back into the mainstream, and that will be healthy for our American culture. To fight back in the culture war, we must not shy away from using political power, because our enemies do it currently against us. To fight within the libertarian frame that the government cannot be involved is akin to fighting a lion with both hands tied behind your back. We must make red states feel unbearable to the left, just as they have made blue states feel unbearable to us. This will contain the spread of leftism and help save the country. Restricting contraceptives could be a useful tool in that fight. Not to mention, it will bring back a more moral populace who actually thinks about the consequences of their decisions. The question is, how far will Republicans be willing to go? The second case Thomas mentions is Lawrence v. Texas, in which the court ruled that any and all anti-sodomy laws are deemed unconstitutional, once again due to the Fourth Amendment's Due Process Clause. Again, this fictitious right to privacy is what safeguards legal protections for one of the sins that cry out to heaven the loudest. Now, I am well aware that this case is the most controversial of the three to even discuss overturning, mainly because it is nearly impossible to enforce, but also because of how private these actions are when legitimately confined to the bedroom. Unfortunately, this has not been contained to two consenting adults in the bedroom, and causes far too many public obscenities during the month of June in particular, even in front of children. The slippery slope is real, people, but Thomas is simply saying that this ruling ignores the intent of the Fourth Amendment, similar to how Roe v. Wade did. Therefore, its precedent is not concrete. Would any conservative state actually consider implementing anti-sodomy laws in the 21st century? Maybe one or two, but it's very unlikely. There would be no widespread appeal similar to what we see happening here in the aftermath of Dobbs. But that does not mean it should not be a possibility for states in the future. Remember, America is a Christian nation. Even if some of those Christians practice a watered-down, secularized shell of their faith. Sodomy is quite literally named after the city of Sodom from the Bible, in which people who engaged in this type of activity had hellfire rain down upon them from the heavens for their perverted actions. This is a clear-cut issue for all real Christians. Will the court get into this one? Probably not anytime soon, but the question of its weakened precedent still stands. Lastly, Thomas mentioned Obergefell v. Hodges. Now, this case is the most relevant of the three. It was only decided 7 years ago, and over 30% of the population still oppose the outcome, the legal recognition of same-sex marriage. The majority of people in Arkansas and Mississippi still oppose same-sex marriage, as well as the plurality in Alabama. A significant portion of the population is just indifferent to the issue. Christians, for the most part, still strongly believe marriage is between one man and one woman, and any of these deeply Christian states could pass laws which get challenged and bring the issue up before the court for debate once again. It could happen even in the next decade, but we'll have to see. So the question is, do any of the other justices besides Thomas have the guts to overturn this decision? In 2015, Obergefell was only a 5-4 decision, with both Thomas, Alito, and Roberts in the minority. If joined by the three justices appointed under Trump, they could have a 6-3 majority to overturn this satanic and unconstitutional precedent. Sadly, Roberts has shifted drastically to the center-left after the death of the great Antonin Scalia and the retirement of Justice Anthony Kennedy. It is doubtful he would still uphold his own prior dissent, which states that the right is simply not found in the Constitution. But it was also surprising that he ruled with the majority in the Dobbs case, so don't rule anything out. It is still possible that in this new 6-3 court, now devoid of Ginsburg, even without Roberts, a 5-4 ruling to overturn Obergefell could still happen, but only if the issue is brought before the court once again. So how should we interpret Justice Clarence Thomas's Dobbs opinion? Really, this all comes back to the states. As we saw with the pro-life movement, these deeply Christian, conservative states pushed back against the liberal march towards progress and passed heartbeat bills and pro-life legislation which directly ignored the Roe precedent. Those laws worked their way back up through the courts and reached the highest court in the land, eventually leading to the overturning of that precedent. I think what Justice Thomas is signaling is that we must continue with this approach if we wish to restore the integrity of our Supreme Court and undo decisions that have blatantly spat in the face of the founders and their original intent of the Constitution. We need a pro-family, traditionalist movement to continue the work started by the broad coalition that makes up the pro-life movement. It won't be led by the same people. Many pro-life leaders do not care about these other issues. Many pro-life influencers are liberal feminists on everything but infanticide and appeal to an audience who are not in favor of these other changes. That does not mean the constitutional questions do not still exist. The work must continue. We must take the baton of judicial appeal and run with it. Run with it before our greatest champion on the court retires. Run with it while we still have the momentum. run with it to honor our founders, and run with it to honor the Christian nation they built. That is what comes next. Thank you, and God bless America. Hey guys, thanks for watching. If you liked this video, please leave a like and subscribe. And if you made it to the end, comment what part of the culture war you are most excited to tackle next. Thank you for watching, and I will see you in the next one. Take care, guys.